Hi everyone, welcome to Ask ALB, a podcast that features interviews with prominent lawyers and thought leaders. My name is Julian from Asian Legal Business. Please note that the contents of this podcast is not to be taken as professional advice, but just general guideposts for you to think through the issues you face. This episode will focus on accelerating the due diligence assessment in an M&A. And we are very pleased to have our guest James Liu, Managing Director and Beijing Director of the BGR Group, join this episode. During the course of his professional career, James has advised on venture investments both in the United States and China, represented multinational clients in their foreign direct investments in China, advised on mergers and acquisition deals, joint venture setups, and restructurings, and all aspects of investments. In recent years, James' practice has extended to representing clients in the People's Republic of China, both state-owned and private clients on outbound investments in Europe and in the United States. James has been involved in all aspects of investments and M&A transactions in China, from the initial planning and structuring through to the approval and implementation. So welcome, James. How are you doing, James?
I'm doing fine. Thank you, Julian. How are you?
I'm doing well as well. So let's begin. Can you tell our audience a little bit more about yourself and BGR Group?
I'll be happy to. My name is James Liu. I was born and raised in China, went to college, went to Peking University, and in the 80s, I received a scholarship and went to the US for postgraduate studies. I started my career as a college teacher. I taught French and Chinese at University of Delaware, and while teaching, I got enrolled in the MBA program. And before I finished my MBA, I also received a scholarship to go to law school. I received my JD, passed the Maryland bar, and became a lawyer. In 2002, my firm opened a Shanghai office and sent me back to Shanghai, to China. So I have been back to China and working for the past 19 years now. In 2016, while helping a client, a very large SOE, who faced a US sanction, I received the request from my client to help them to lift the sanction on the company by the US Department of State. So I interviewed BGR and hired BGR on behalf of the client. And in the process of working with BGR, I got to know BGR. And they wanted to open an office back in 2016 and early 2017. They invited me to join BGR as the head of their China operations. So I'm wearing two hats now. I'm still a lawyer, but at the same time, I think I added a very different and yet very dynamic dimension to my practice, which is, let me talk about the BGR for a very short moment. BGR is a premium, bipartisan, lobbying, government relations, and strategic communications firm. It is based in Washington, D.C. The firm was founded by the former governor of Mississippi and the chairman of the Republican National Committee, Haley Barbour, and two of his associates, Lanny Griffiths and Ed Rogers. So BGRs are the initials of the three last names of the three founders. After I joined, BGR has a very solid lobbying and government relations and public relations practice. We do federal and state and local lobbying. We do what is called hard lobbying. When it comes to strategic communications, we make sure that we bring our clients and get the attention of the stakeholders at the White House or different agencies at the federal government or state and local governments. To illustrate what I mean by lobbying, let me give you an example. Our client, while helping, my first client to solve the sanction issues, we had a request from a private but very, very large steel maker in China. And they were listed in the U.S. legislation to be sanctioned because they were buying coal from North Korea. So when they found us, the legislation has been read twice already in the Senate. And as you know, the procedure, if the legislation is being read 3 times, then you will go to the floor for a vote, and you will certainly pass the Senate, and then you will move on to the House, and then all the way to White House for the president's signature before it becomes law. So time was very pressing. We took our client, prepared them, and we hired a law firm from Washington, D.C., which we know well. And together we drafted their entire compliance program within 2 weeks. And then we took the client to Washington, D.C. We paid a visit to the sponsor of the legislation, of the draft law. We visited the senator's office. We visited the Foreign Affairs Committee on the Senate. And also we talked to all the stakeholders in this piece of legislation. The reception from the sponsor of the draft law was surprisingly warm. The senator told our client that they were the very first Chinese client targeted for sanction, but they were the first one to reach out to U.S. legislators, senators or congressmen, and explain their position. And I remember very clearly one thing that the senator told our client that the purpose of our law is not to punish anybody, but to change behavior. So if you commit to not buying coal from North Korea, then we will take that into consideration. Long story short, after a pretty intense 3 weeks of communications with the Senate and the senators who sponsored the bill, we were able to take our client's name off the potential sanction list, which really helped our clients because, as you may know, that the power of the U.S. sanctions, does not rest within the piece of legislation itself, but rather, if you are on the sanctions list, then your international monetary transactions can be stopped in New York. So all your international wires will be basically cut off. And while my client had loans with many major banks in China, and the banks threatened to kick them out of their banking system. That's really the consequences of the U.S. the CEO's attention. Out of our joint efforts, they were able to avoid being sanctioned. So that tells you several things, to explain exactly what lobby is. Number one, why we call ourselves being able to do the quote-unquote strategic communications. That is, once you have an issue with the U.S. government, the worst thing to do is to trying to hide, bury your head in the sand and pretend you don't see the problem coming. They will come. So the right strategy is to approach them and explain to them and show them that you are a normal business, and in the course of a normal business transaction, you may, you cross the line and became a target in the crosshair in the U.S. sanctions. So once you have the channels to effectively communicate your positions, then it's fairly common in my new profession, in this lobbying profession, to help the U.S. legislators or the U.S. government to see your position and to understand better your position, and therefore reach a compromise or a solution to your dilemma.
Okay, that's very, very interesting thing that you're involved with. So, okay, so let's just get down to the topic for today, which is accelerating due diligence assessments in the M&A. Now, in the M&A process, obviously, the due diligence allows the buyers to confirm important information about the seller, such as contracts, finances, and customers. And by gathering this information, I suppose the buyer is better equipped to make an informed decision and close the deal with a certain sense of security. Now, how can our audience prepare their due diligence team for this process or for success?
My take has always been, because of my MBA background, I am able to look at any transaction, any deal, first from the business side, because I believe that to be a good lawyer, you have to be able to understand the business logic, and talk to your client, or if you are in-house counsel, talk to the business BU head or the project head, and ask them what exactly is your goal and what is the purpose of your transaction. Once you have a good understanding of that business goal, then you will be in a better position to understand the legal pitfalls, the downfalls, the potential traps in this transaction. So I think this is number one risk assessment you must take. And secondly, if, for example, different targets requires different approaches when it comes to due diligence. So have a thorough understanding of the target is also a prerequisite to any successful due diligence process that you lead. For example, if your target is a startup company, a high-tech startup company, or whether the target is a growth stage, or a late stage company ready for IPO, or is a public company. These four types of targets requires a slightly different approach to the due diligence process, and then you need to emphasize, on different areas in your process. Let me take, say, a high-tech startup as an example. When you look at the high-tech startup, the target, and then after you understand your business goal from your business colleagues, then you know that most of the time, a startup, their most valuable assets are the intellectual property rights. Because in the high-tech area, industry, the brain power of that target probably is more important than their sales volumes. And a lot of times, the target doesn't even have any sales because of the early stage in their development. So pay very close attention to intellectual property. Of course, the usual suspect, you have to take care of them, whether the company is being registered properly and so on and so forth. But the emphasis should be on two areas, I believe. Number one, intellectual property rights, whether there's any potential infringement, or who are your competitors, and whether these IPs, which are the most valuable assets in this target, whether they potentially infringe upon anybody else's rights, and then creating conflicts and lawsuits, then that would have a major negative impact on the business prospect as well as the valuation of the target. And then the human resources, because the CTO's position would be crucial. For example, who is the CEO, the leader, and the real driver of this company. So I believe that if you are a seasoned, experienced lawyer, and then you probably would agree with me that these two areas are very much the first things you look at. You look into very carefully. If you find anything major, any serious issue, then you may rethink your strategy. And as lawyer, and we are trained to be the goalkeeper, right? Mm-hmm. So we are really we are trained to think of the worst case scenario, the downside first, before you think about the upside. Our thought process is very different from the business side. The business people would look at how much money they're going to make in this deal. You, as a lawyer, we look at the risk first and then come up with how to avoid these risks. That would be my recommendation, my advice.
Right. How do you go about identifying some of these critical issues that are specific to their business? I think you mentioned that for tech companies, obviously the intellectual property is very, very important. Then how about other companies? What advice can you give our audience on how to look into these deal-specific issues that are important to their business?
Then in general, I think number one, as a practical matter, always organize your team with experienced lawyers. Look at your own team and say, okay, depending on the size of the deal, so you have a good assessment of how much work and manpower you need to put into this deal, right? And then look at the composition of your team. You may need a couple young lawyers, and they can be helpful in the process, but you do need a couple experienced lawyers, say 5, 6, 7 years experience post qualification, and you need to know your team well.
Ask ALB can be streamed on iTunes.
My approach, dealing with any deals. After that, when you feel confident that your team can handle the work, then come up with a list of due diligence list and discuss with your business unit colleagues and ask them, well, please read this list carefully, and do you have any suggestions? Does my list cover all areas of your concerns? And you'll find that this step, if you do well and you do a good job in here, it saves a lot of time down the road and avoid mistakes you make. So did I answer your question, or but these are really just from my experience.
So sometimes when you buy an organization, you may be a little concerned. Will you be buying a violation? Because how can an organization manage any compliance risk or corruption risk in a deal?
That's a hard question.
Yeah.
And but it's also a very practical question. General counsels face that question every single day. As a outside lawyer, when we advise our clients, I think my number one rule is that I lay out the risk and explain the legal pitfalls very clearly to my clients and tell them that these are potential red flags. And as a lawyer, as your lawyer, I'm going to raise these red flags. I'm going to flag these issues to you. That's first step. Step number two, talk to your business colleagues and try to find a way, number one, to avoid them. And number three, have your own compliance program in place. So you have a systematic mechanism in place to avoid a institutional mistake when it runs into a, cross the red line, so to speak. That would be my advice. But don't, especially younger lawyers, sometimes they are afraid to challenge their client. They are afraid that, if their efforts, their judgment, is viewed by their bosses or by the business colleagues as impediment to the deal, then they may become less popular than they wish. But my advice is, as a lawyer, you always remember your ethics, and you need to tell your client, and you owe them a duty to explain these red flags in a very clear and unequivocal fashion. And then that is not to say that your job is there to kill the deal. But, what is more important in here is help your client to understand the risk, but come up with a solution, how to avoid them.
Right. But do you have any specific advice on how someone can avoid liabilities of past violations in an M&A target?
Let me give you an example in, let's say, healthcare industry, which is everybody knows that the hongbao problem in let's say drug companies or device companies in the sales process, right? And I think the government knows the problem really well. They know what is going on. Say if you are a private equity fund and you are buying into a drug company, and you should assume as the lawyer that they have some practices, business practices that are not, in compliance with the regulations. Then you need to identify them, understand them, and the most practical solution is to establish a firewall. In law school, we learn that it's a China wall, right? And you basically contain those problems to a segment in the deal that is not related, that cannot be legally traced back to your client. So you protect them, you provide legal protection to them.
Kind of like ring fencing, I suppose.
Yes, that's another way to put it. Yeah.
Yeah. Please continue.
That I think is happening every single day in real practice. Your law school professors probably cannot teach you that. But if you are a practicing lawyer or if you are a general counsel in a company, then you'll face these issues day in and day out. So if you are a general counsel, you're in-house, then you really need to have a training program in place within your organization. And that has to be institutionalized together with your compliance program. And educate the business people, the sales people. We know how hard the job is because within any businesses, any companies, the CEO probably will not listen to the lawyers every time, but they will listen to the salesman, to the salespeople. When they open their mouth, they get the CEO's attention, and so that's as a in-house counsel. Then your job is twofold. Number one, you need to make sure that you get the attention of the real decision maker. And number two, you also need to safeguard the interest of the company, because you're not the CEO's or the chairman's lawyer. Your duty, you own your duty to that corporation, to that entity. That's where your ultimate loyalty should lie. So in that dilemma, how do you balance these two very demanding goals? That's an art. It's not a science. But my final advice on this topic is be firm but polite. That's the job of a lawyer.
Okay. We have this question from our readers quite often, the people who come to attend our events. They ask, what measures can you take to minimize cross-border M&A disputes? Is there anything that can be done during the due diligence process, in your opinion?
Oh, absolutely. I think, as we always joke, before you get to the deal, then do your homework, right? That homework is the due diligence, and is even before a formal due diligence process. In a cross-border setting, I think, in addition to the conventional due diligence process, my experience in the past 5-6 years working with BGR and heading BGR's China practice also taught me that the political risk is also of paramount importance in cross-border transactions. I came to realize that as the government has a policy to encourage Chinese companies, SOEs or private companies, to be more quote-unquote international, but how do you judge? What are the criteria you use to say that, oh, this company is more international than the other company? To me, I have my private gauge. I would take up my own ruler and measure, my client, and to see how international they are. That is whether, number one, they understand the local politics, they understand the rules of engagement, and whether they can engage firms like BGR to help them to hold their hand and navigate the complicated political nuances. That, I think, is many companies engaging in cross-border transactions do not realize that. They take a domestic mindset. They treat a cross-border transaction as a domestic transaction. And that is not to say they're not smart business people, but they're just simply inexperienced. In that inexperience, then they would just apply their experience and the rules in a domestic transaction and think consciously or subconsciously believe that it'll also work in a cross-border transaction. And I see companies got into trouble, 80% of the time that could have been avoided had they adopted a different approach. So the political due diligence is very, very important. For example, you go into a Middle East, or let's say you go to the US and you need to hire an advisor, someone who knows the politics. And then you need to do a due diligence on the person, on your advisor as well, and understand which political fraction that he represents, and what kind of a political access he has, whether he really does have that the power that he claims to have, or he's just talking. All this, in addition to the legal conventional due diligence, then the political risk assessment is increasingly important. As you know, as our audience must know, that the political tension between China and the US increased tremendously in the past 5 years. During the Trump administration, the nature of the bilateral relationship took a fairly dramatic turn. So in that backdrop, against this background, I would encourage any in-house lawyers, when they consider a cross-border transaction, to add a political risk assessment, or what we call a due diligence, a political due diligence, to their long list of due diligence questionnaires, and be prepared for any political turbulence that may impact their deals.
Okay. Can you share with us some ideas on how to get to the right level of analysis then? I mean, based on what you've discussed, due diligence can go on for a very, very long time, because you can never have too much analysis anyway. There's a political aspect to look into. You have to look into the potential risk of buying a valuation and so forth. There can never be too much analysis, and it can go on for quite a long time. How do you tell that you have enough analysis so that we can take the deal to the next stage of the process?
I wanted to say it's simple, but it's also not simple, because there's a lot of homework you must do before it becomes simple. Hire the right people to do the right work. That's my experience, and has always been my approach. The biggest risk for any advisor, legal or otherwise, is for the person to know enough to be dangerous. By that is the person knows somewhat, has certain knowledge level, but he or she doesn't really know it. Then, based on his or her assumption, then it may become the advice may not be the best advice that you can give to your client at the moment. I think that's something that you should absolutely avoid as a in-house counsel, or as a outside lawyer. You should always know what you don't know. And once you know that you don't know a certain area, you lack the expertise in that area, run for help. Go to find the professionals. And there are many good firms out there who specialize in a certain area of and they can be very effective. So that's part of the doing homework requirement in my experience.
Okay. Finally, this is not really related to due diligence, but How do you think the pandemic affected M&A work, especially for cross-border deals? And do you have any advice or suggestions on how to overcome these hurdles?
Pandemic has, I would say, minimum impact on domestic deals. The M&A market is still there, although very large PE funds, complain that good targets are more difficult to find because of the size of their requirement of the deal. But good targets are out there. You need to have your deal team to look for it. But cross-border transaction had saw a major hit in the past year during the pandemic, the lockdown, as many countries had to lock down due to the pandemic. Business meetings got canceled, and the face-to-face meeting, which are the most effective ways of communication in a cross-border transaction, just could not take place. All this adds to the political difficulties. Then it becomes just a lot more difficult for people who want to do cross-border transactions.
Okay.
So, in summary, in cross-border transactions, especially in the new era, as we enter, the first year of the Biden administration, and 4 years down the road and beyond, I would share my client, my audience, this experience that I come to realize that in any cross-border transactions, there's three levels of logic. The basic, at the first level is the business logic. Why you want to do the deal? Because the deal will help my business to grow, to make more money. So that's the economics. In the middle, the logic would be legal. That's our lawyers would come in. And lawyers and laws are, by definition, set of rules that you'll follow. You'll help your clients to draft an airtight contract, that beyond the attacks, and then to make sure that your client's interest will be better protected. But that's not all. That's not a complete set of business picture that you look at as your good advisor. A good advisor would also look at the third level, the upper level logic of the deal. That's politics. As the saying goes, rules are rules, but law is politics. So the very top, especially when it comes to bigger deals, large deals in cross-border setting, always keep the politics in the back of your mind, and be diligent and be aware of political issues in your deal.
Okay. Thank you so much for the insights. So with that, we've come to the end of today's episode of Ask ALB. I'd really like to thank James for joining us today. James, do you have any final words to give our listeners on due diligence in an M&A? Any final words at all?
Sure. In my experience, I believe that a good in-house counsel would always have a list of outside advisors that he can trust, he can reach out to in real time. That's the one of the most time-saving and efficient way to function as an in-house counsel.
Okay. Thank you very much, James. Where can our listeners find you if they have any questions pertaining to issues that we've discussed today?
They can find me on our website and through email. Our website is www.bgrdc.com. We also have a page in Chinese, which we recently added. And also my email is jliu@bgrchina.com.
Cool. So with that, I'd like to thank James and thank everyone for joining us today. Remember, Ask ALB can be streamed on iTunes, Spotify, or Google Podcast. And we'll catch you in the next episode. Thank you, everyone, and thank you, James.